right, this is the 140-160 class, and this will be some congressional warm-up for the record. Mr. President, how many times have we heard the same line? If ordinary Americans can balance their family budgets, if state governments can balance their budgets, and if business can balance their budgets, why can't the federal government? It is a good question. The real answer is that families, states, and businesses balance their operating budgets most of the time, but they also borrow for long-term investments. Families borrow to buy a house. They borrow to buy a car. States borrow for capital projects that will benefit future generations. Every day, individuals borrow to invest in their future by taking student loans. If they did not, most would have no future, especially in today's increasingly technological age. That is why they do not balance all receipts and expenditures. They balance only their operating budgets. By contrast, Mr. President, this amendment lumps the capital and operating budgets together and makes no distinction between investments and operational expenses. This ignores the basic standards of budgeting under which virtually every business in America operates. As a former CEO of a major public corporation, Mr. President, I can attest to that. Commingling the capital and operating budgets threatens to rob us of investments that are critical to our nation's future. Mr. President, investments are necessary in our nation's roads, in our bridges, in our airports, in our air traffic control systems, in the information superhighway, and the technology of tomorrow. To ignore these kinds of investments is to ignore our own future. We hear it said many times that if we do not have the balanced budget amendment, we are delegating to our children and future generations huge obligations to repay debt, interest, and principal. Mr. President, as we all know, if you do not make investments in tomorrow, that really deprives our children and our grandchildren of opportunities to learn, to earn, to work, to develop. That is when the real penalty to our children and grandchildren is going to come into place, and we can do something about it. We can reduce our spending, and we can proceed to a closer balance of our budgets. We have seen in the last few years with the President's leadership, we have been able to substantially cut our annual deficit somewhere around $500 billion over the 3-year period as contemplated. This amendment also violates a fundamental principle upon which our nation was founded, and that is the principle of no taxation without representation. The balanced budget amendment is intended to encourage the Congress and the President to agree on measures to eliminate the deficit. But what happens if the two branches disagree? What happens if, notwithstanding the amendment, the budget is still not in balance? The answer, most likely, at least as presently designed, is that the courts eventually would step in to implement the constitutional requirement. That could mean not only cuts in Social Security, Medicare, and other federal benefits, but substantial tax increases. Some proponents of a balanced budget amendment may say that that is not their intent, but the courts will not be able to rely on such claims. First, there is real disagreement among amendment proponents, and some insist the courts must enforce the amendment. More importantly, there is nothing in the amendment itself that seeks to preclude the courts from enforcing the amendment's provisions. This contrasts starkly with other versions of a balanced budget amendment. And so the obvious question for the courts will be, if the amendment is not intended to preclude judicial enforcement, why does it not include an explicit statement to that effect? Mr. President, the court's power to interpret and enforce the Constitution has been well established since the famed case of Marbury versus Madison. That long established power is not likely to be relinquished. So, Mr. President, the threat of judicial taxation under a balanced budget amendment is not hypothetical. It is very real, and that is not just my opinion. Legal experts of all political stripes agree. The conservative former Supreme Court nominee, Robert Bork, who also opposes the balanced budget amendment, has warned that the amendment could lead to tax increases mandated by unelected, lifetime tenured judges. Mr. President, over 200 years ago, this country was born after citizens were burdened with stiff tax increases imposed by distant elite rulers who did not represent the people and who were unaccountable to them. The rallying cry of our oppressed forefathers was clear and compelling, and that same rallying cry applies to this amendment. No taxation without representation. It is permanently embedded in the earliest of our school children. They know about that episode in American history. They know the impact that had in the creation of this wonderful democracy of ours. Mr. President, it is bad enough that ordinary Americans are now paying an unfair portion of the tax burden, but that burden may get a lot heavier when judges inherit the task of balancing the budget. After all, the judiciary branch is the branch of government that, by design, is most insulated from the public. In fact, judges are supposed to ignore public opinion. Mr. President, if we think the American people are angry today, just wait. Wait until they get hit with a huge tax increase by a district court judge who they have never heard of, never voted for, and they will never be able to vote out of office. The reaction will make the famous Boston insurrection look really like a Tea Party. I know that some amendment proponents are convinced that the courts will not intervene to enforce this amendment, but supporters of the amendment cannot have it both ways. If this amendment really will force Congress to reduce the deficit, who is going to force us if not the courts? After all, Congress has already passed laws to force itself to balance the budget. but without an effective enforcement mechanism, we simply sidestepped our own law. And now amendment proponents assure us that the same evasion will not be possible under a constitutional amendment. But just as prohibition did not stop drinking because it was unenforceable, a balanced budget will not stop spending if courts are impotent to enforce it. I find it absolutely astounding to hear amendment proponents argue that the courts would never enforce this amendment. We are talking about an amendment to the Constitution of the United States, not a sense of the Congress resolution. Can the proponents really believe that the balanced budget amendment is nothing more than a meaningless scrap of paper that cannot be enforced? Could they really be that cynical? I do not think so, Mr. President, and I do not think the courts will either. As Lawrence Tribe and Robert Bork concluded, the courts will not presume that this is a meaningless and utterly unenforceable scrap of paper, and that is why the threat of judicial taxation is so real. Mr. President, there is no need to rely on the judiciary to reduce the deficit. Congress could do it. We could start now if we had the political will. Okay, this will be some jury charge material for the record. Ladies and gentlemen of the jury, you have been shown a number of summary charts and other demonstrative exhibits. Please keep in mind that these charts and exhibits were used mainly as summaries of testimony and documents that were presented in this case. The charts and exhibits act as aids for you in examining what is going on in the courtroom. They are not, however, evidence in and of themselves. They are demonstrations, sometimes graphic in nature, of evidence. The weight that you give to it determines the value and the significance of the rest of the exhibits. To that extent, these exhibits do confirm to what you determine the underlying facts to be in this case, and you should accept them. To the extent that these exhibits may differ from what you determine the evidence to be, you may reject them. Ladies and gentlemen of the jury, you should not be concerned about whether or not the evidence is direct or circumstantial. Both types of evidence are proper and correct for your consideration. Neither type enjoys preference over the other in the eyes of the law. Direct evidence is the testimony of one who has actual knowledge of a fact. This includes eyewitnesses. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact that may be in dispute. Circumstantial evidence is sometimes called indirect evidence, which means it is not direct in nature. Now, if you recall, ladies and gentlemen of the jury, at the beginning of the trial, I gave you an example of an eyewitness's statement that said the following: "It's snowing." It is direct evidence. Now, this is opposed to observing signs from which a conclusion could be drawn that it is snowing outside. That would be circumstantial evidence. In assessing circumstantial evidence, ladies and gentlemen of the jury, you should use your reason, common sense, and experience to infer from established facts the existence or non-existence of another fact. You should consider only the evidence, but you are permitted to draw reasonable inferences from testimony and exhibits as you believe are justified in light of your everyday experiences. In other words, you may make deductions and come to conclusions that reason and common sense lead you to learn from the facts that have been established by other facts. Now, ladies and gentlemen, an inference is a deduction or a conclusion that reasoning and common sense prompt someone with a reasonable mind to draw facts that have been proven by the evidence. You must remember that not all possible conclusions are fair inferences, and they should not become an inference unless you feel it is a legitimate inference. The law makes no particular distinction between the weight you give to either direct or circumstantial evidence, nor does it make a distinction between reasonable inferences that you may draw from direct or circumstantial evidence. You must consider all of the evidence that is presented to you, ladies and gentlemen, here in this courtroom. You must look at it and weigh it and evaluate it. You do not have to accept all of the evidence as true and accurate. You must decide whether you believe what each witness said. You must decide how important each witness's testimony is. In making that decision, you may believe or disbelieve any witness. You may believe all of a witness's testimony or part of it. You must not take into account the number of witnesses who are called to testify by one side or the other. In deciding whether or not to believe a witness's testimony, you must ask yourself several questions. Did the witness appear to be telling the truth? Did the witness have any personal interest in the outcome of the case or a case that is related to this one? Did the witness seem to have a good memory of the events relating to the case? Did the witness have the opportunity and ability to observe carefully and accurately the things about which he or she testified? Did the witness appear to understand the questions clearly? Was the witness able to answer the questions? Did the witness's testimony differ from other testimony presented here in the courtroom? Did the witness seem to be candid and forthright? Did you notice a difference in demeanor or storyline when the witness was taken on direct examination as opposed to cross-examination? Was the witness's testimony consistent? Did the witness's testimony contradict or conflict with another witness's testimony about the same facts? Did the witness appear to have personal knowledge about what he or she was talking about? These are just some of the kinds of common sense questions you should ask yourself in order to decide whether or not a witness was truthful while on the stand. You may ask questions during your deliberation process to clarify or update a situation if need be. Ladies and gentlemen of the jury, the weight that you give to each witness's testimony should not be affected by prejudice, bias, or some other motive. You should also ask yourself whether evidence was offered that tended to prove that a witness testified falsely concerning some important fact. You should also consider whether evidence was offered that was different from the testimony he or she gave before you during the trial. You may also consider A witness's inaction that is inconsistent with his or her courtroom testimony in order to determine the witness's credibility. Ladies and gentlemen, this is not an easy task, nor did counsel or myself say it would be an easy task. You should keep in mind that a simple mistake by a witness does not necessarily mean that the witness was not telling the truth. People naturally tend to forget. People make misstatements. Some people have lapses of memory or tell an unintentional falsehood. If you find that a witness has testified falsely as to any material fact, or if you find that a witness has been previously untruthful when testifying under oath, you may reject that witness's testimony in whole or in part, or you may accept only those parts that you believe are truthful or that are supported by other independent evidence in this case. Remember, ladies and gentlemen of the jury, you are the sole judges of the credibility of the witnesses.